Hi, I'm Claudia Brown Coulter with Pivotal Peace. I'm your go-to mediator for navigating divorce while parenting children with special needs. I am also a legal document assistant, LDA, based in the greater Los Angeles area. We're talking about finishing your divorce. And if you got kids, you got to figure out what you're going to do with them. So let's talk about these important forms as you are navigating this divorce process. So they're minors. You got to provide for them. You got to know where they're going to live and where they're going to go. And they have to know too. Kids thrive off of predictability and routine, and so do you. So we got to make sure that they know what's happening because that creates safety for them. As you are filling out your initial petition or your response, it's going to ask you about the children. Now, at this point, you can include a detailed parenting plan, but it's not uncommon for people to not know. It's okay. As you're filling this out, if you're like, man, I don't know, I've been thinking about this for a long time, and that's the thing that's been holding me up. I don't know how we're going to do this for our kids. That's okay. I have people who are trying different plans. They're in the process of mediation. They're trying a 2255. Then they're trying a 3443 or something or other, or 223. Week on, week off. They're trying things to see how it works for them and to see how it works for their kid. That's brilliant. I mean, I think it's brilliant because then you get a little trial and error and you can see how it works. And as your child grows, things will change. So you're going to have to mark if there's going to be sole legal custody or joint legal custody, and sole physical custody or joint physical custody. And if you choose sole physical custody, then you've got to mark things about visitation, right? Because then the person is just visiting the other parent. If it's joint physical custody, they are actually living with the other parent. Let me clarify this. Joint physical custody does not mean 50-50. Just because the court thinks 50-50 is best doesn't mean that 50-50 is best for your child or for your family. Joint physical custody is not an automatic 50-50 default. That just means the kid lives with both of you. They might live with you 6 days a week and with the other parent 1 day a week. It's still joint physical custody. Okay. So you have to mark that at minimum. You got to mark that on there. When you get to your financial disclosures, you have to fill those out. We use these in mediation to determine support. If you do not have children and you are not seeking spousal support, out of the 4 forms that are being filed, you probably only have to file 1. But if there's any sort of support involved, you are going to have to file 2. That's the standard. We usually just file the 2. That's the maximum that you have to file, the 141 and the 150. If support is an issue, you have to file that 150. People don't like to do that because they feel like it's a bit invasive. It's not as invasive as a schedule of assets and debts. But the court requires you to file that if support is ordered. So, you're at this point. You filed. Maybe your spouse responded. Maybe they didn't. You've completed your financial disclosures. You're ready to mediate. How are we going to figure this out? So, you can be like that couple, and you can try different plans. You can think about what your kids need. Depending on the age of your children, you can give them a voice. Kids have a voice, not a choice. Doesn't matter how old they are, they have a voice. Just because the court will listen to them, the court doesn't let them decide, right? Usually a court will take their thoughts and considerations into consideration once they're about 14, but nothing's set in stone. The judge doesn't have to do that. You don't have to do that either. They're not in control. You are in control. They are the minor. You are not. What's that? Is it the major? I guess it's just the adult. You just the adult. Okay, you are their guardian. So you can bring them into that conversation. You can talk about their school schedule, their extracurricular. You could talk about your work schedule, your spouse's work schedule, and how it's all going to work together. Maybe someone is going to move away, like far away. These are all conversations you can have so you can craft the plan that is going to help your children thrive. Once you are there, you can just write it up shorthand, right? You could just write it, type it in the document. You will need to submit the 341. The 341 isn't a standalone document that's attached to your divorce judgment. And you can list things about your proposed schedule. And you can add attachments and things like that. And you can just kind of freehand it and type something in there. If you want more details, there are a whole host of official addendums. There's a 341A and the 341B and the 341C and the E and the D. Right, they got a lot. Okay, so the 341A is for supervised visitation. Probably won't be using that one. B is for child abduction prevention. Most of my clients don't use that one either. C, a lot of clients use, and there's a section on 341 that has this as well. It's about the holiday schedule. So C just kind of maps out some holidays. You can use it or not. You can just write down on the 341 what you want it to be, or you can write on the 341C. It's totally up to you. The 341D is if you have any extra provisions about the physical custody, or E if you have extra provisions about the legal custody. And sometimes clients fill out D and E. I see a lot of clients, they like to fill out C, but it really depends on the holidays and how it works for their families. I think sometimes too, it just helps people feel better, like they're doing something, to have something concrete that they can see about the holidays. It is absolutely up to you. It's neither good nor bad. It's about what works for you and your family. And also what works for your brain. Like, how do you see it on paper? Because if you see it on paper straight like this and that works for your brain, great. Use that form. Make it as concrete as possible. That's smart. The other thing, after the 341 comes the 342. And the 342 is about child support. So to this 342, you are listing the things about support and how much will be. You are also needing to attach a DissoMaster report, because there was a guideline child support amount. Even if you and your spouse are sharing 50-50 custody, you still have to do a DissoMaster report. A 50-50 custody timeshare does not mean that there's no child support. It doesn't mean it's automatically zero. It usually is zero, but a DissoMaster, I've ran a DissoMaster before where it was like, parent A owes parent B $6. Ridiculous. But they had to attach it. They didn't have to agree to $6. They agreed to $0. That's okay. That's cool. You agreed to $0. Now, if you do anything other than the guideline amount, you need to attach a 341A that says, hey, we're submitting this and it is above guideline. That happens. Sometimes people want to pay more, or it's below guideline. And here's the reasons why. It's pretty straightforward. The other thing is a standalone document. It's a 191, and it's not part of your final, how do I explain this? The court requires it. It's held just in case. It's a child support registry, but this isn't like, we are going to garnish your wages. It's just more nosy information that they want about you, but you're required to fill it out. It's going to ask about your social security number, your driver's license number. I usually tip, if you can get away with just putting the last four of your social on there, and for your kids, that's better, right? Identity issues, just put the last four, and usually the court will take it. If they don't, then that's another story. But you need to fill out these additional things. It once again lists how much is being paid a month, even if it's zero amount, who's paying who, when that payment's going to happen. And that gets either mailed in or it gets e-filed in. It depends on the court. And that's it. So this is the way to document your plan, but you've had conversations about this. The other thing is, these forms are rigid. So you may have created a portion of your plan that is very, very different, or there isn't a form that allows you to be creative. You can always attach the MC025 to any court form in family law, and it's basically a blank sheet of paper, and you can input, okay, they're going to be with me on Sunday and him on Wednesday, Thursday, Friday, and you can document it. You can get as detailed as you want. We're going to pick them up on this day. This is our exchange time. You can always click a little box and add an attachment, a blank sheet of paper. I really encourage people to be as clear as possible. I've seen other people be like, oh no, don't be detailed, don't be specific. Listen, you want to be specific about these custodial arrangements so that in the event there is a disagreement, you fall back on your divorce decree. You fall back on this parenting plan. But this parenting plan is not your God, okay? If you guys agree to do something different in the meantime, fine. If your parenting plan says drop off is at 8 a.m., but you want to do 11 a.m. and your former spouse agrees, fine, okay? Like, no one's monitoring that. It's you guys. If you can't agree, you default to the agreement. Ideally, you just kind of put it away. You put it to the side. We have this agreement. This is our default. This is what we're going to do. But we're going to work hard to get along. Because here's what happens. When people don't have a clear agreement, when they agree to agree, I kid you not, they agree to agree because they're getting a divorce, and so they're naturally going to agree about everything. They're the ones who have conflict on the back end, after the divorce is finalized, because everything is unclear. And so one spouse is running the show, and it's causing a nightmare for the other spouse, and the children aren't getting adequate exposure to their other parent. Be clear now so that you can, and be rigid now in your plan so you can loosen up later on, right? Take the hard work, take the time now to do the hard work so that your life later is easier, so it's safe and predictable. And if it's your custodial day, but your child wants to see the other parent and the other parent is available, let them go. It's going to come back to you. That's going to happen again. So be open. You can't hold something like this. Your children are only children for so long. Have an open hand. Make them feel warm and welcome. Don't prevent them from their other parent. Don't prevent them from having a relationship with their other parent, because if you do, when they grow, they're going to not want to have anything to do with you. Keep your hand open. If it's your day, it's your day. Enjoy your day. You don't have to give up your time just because the other parent asked for it. But if your child's like, I want to go see my other parent, let them. Use your best judgment. But these are human lives, not things. This is not a dog. It's not a cat. It's not property. This is a human life. So be flexible, be open, know what's going to be okay. I know how hard it is. So you can do it. You can do it. So these forms are pretty simple to fill out, and I can help you do that. You guys have a great weekend.